Individual rights in the Constitution. It became apparent to the Founding Fathers that without some kind of compromise regarding a statement of the people's rights, the ratification of the Constitution would be in jeopardy. When the original proposal was made by George Mason, a Virginia delegate, to add a Bill of Rights to the Constitution in 1787, it was turned down by the Federalist forces controlling the convention. However, when the states began the ratification process, it became obvious that the necessary 9 states needed to approve the document would not vote to ratify without an agreement to add a series of amendments that would protect people from the potential abuses of the national government. The Federalists argued initially that a Bill of Rights was not necessary because the states under a federal system would protect their citizens. The Anti-Federalists insisted that these rights be written and included in the proposed Constitution. States such as Massachusetts, South Carolina, New Hampshire, Virginia, and New York agreed to support a Bill of Rights immediately after the Constitution was ratified. In the agreement over whether or not to include a Bill of Rights into the original Constitution, James Madison wrote in Federalist Number 84, "I go further and affirm that Bill of Rights, in the sense and to the extent in which they are contended for, are not only unnecessary in the proposed Constitution, but would even be dangerous." On the other hand, in a letter from the Federalist farmer to the Republican, an anti-Federalist publication, it was written that people and very wise too like to be express and explicit about their essential rights, and not to be forced to claim them on the precarious and unascertained tenure of inferences and general principles. The Anti-Federalist forces prevailed, and the Bill of Rights was adopted in 1791.